The mere notion that you can say, I'm here sitting here in my living room and I'm going to decide that we're going to procreate a child, and I know nothing about this child, particular characteristics or anything, but the one thing I do know is it's from the very beginning of this child's life, be it a him or her, we don't even know what it's going to be yet, I'm going to make the decision that this child will never know his or her parent, his or her father. I have made the decision for them that they will be my child and my partner's child, and they will never know their biological father, for example. I don't know about you. I'll look right in the eye. I don't know if that's civilized or not. I find that to be just unbelievable. Yet, in California today, that's a person's right. I don't know if shutting down sperm banks and making parents, you can stop this fairly quickly, just make the biological father, who does it through a sperm bank, liable for 18 years of the support of his child. Now, not to be too indelicate, but if I pick up a young lady in a bar and we have a one-night stand and she becomes pregnant, I'm on the hook for 18 years, as I should be. However, if I make a donation to a sperm bank, and that's irrespective of whether we intended to have a child, we tried our best to prevent it, we had no, you're on the hook. However, if I make a donation to a sperm bank with this direct and specific intention that this will, my sperm will be used to procreate a child, the law protects me and makes it difficult for my kid even to find out who I am. And I think you would have a hard time, both politically and I think constitutionally, changing that set of facts in California today. Maybe I was born in the wrong century. Let's see, Bill.
Yeah, this whole idea of the court defining what a family is, I don't know if family is defined in law, but there seems to be a flaw in logic about the right to start a family, and really what they seem to be saying, if I'm not mistaken, here really is that in order to be an official family, you have to be recognized in some way, and really what they're saying is that a same-sex couple is established as a family, whereas a single mother with 3 kids isn't an official family. And I don't know if I'm reading too much, but
well,
it seems to be a little bit of a leap in logic.
Okay, I don't think they would say that a single mother with 3 kids doesn't constitute a family, in the sense that I think because that wasn't what was at issue before them. The mother, but now again, you and I are thinking mother, and they're thinking mother, and we're not thinking the same mother. So, and I don't mean this to be pejorative. I mean, it's in reality. You have to stop and think about the reality of California law. The reality of California law is if you intend with a partner to procreate a child and you participate in that in some way, then you become the child's parent-in-law. Now, that's a shorthand version, but it's basically it. So when you say a mother, okay, when you say a mother, you don't necessarily mean a biological mother, and you don't necessarily mean an adoptive mother. Okay? Those folk have certain rights, duties, and obligations regarding their children. Okay? And those duties and obligations are akin to the family. I think more interesting questions are things like, and these are brushed aside, I mean, because they're easily solved in a sense. But there's things called the intestacy statutes. Anybody here know what an intestacy statute is? Yeah, well, it's if you die without a will.
Your property goes to the state.
No, the state has a law that says if you die without a will, then this is what happens to your property. And they basically divvy it up among your wife or spouse and your family. Kids get a certain amount. If you don't have kids, and cousins get a certain amount, or nephews get certain amounts. They divvy it up among their blood relationships. You can't enter into a same-sex partnership in California, if the domestic partnership in California, if you are of a blood relationship which would not allow you to marry. I have no idea what the rationale is anymore for those things. I think that you're talking about, just think about the issue of extended family. The issue of extended family. Family has been redefined, and it is the reason. There's a reason why we call the marriage the first vital cell of society, because it has incredible ramifications that we don't really even think about. We take just for granted, and that's why, in my opinion, you got to hold open. You got to stick your foot in it. You got to hold open that door for the people to be able to have something to say about this, because the judicial class has already spoken. And now, no one's asked me what I think the outcome of this case would be. Thank you. I think that Proposition 8 will be upheld as constitutional as long as the right Anthony Kennedy, the good Anthony Kennedy, shows up that day. And, oh yeah, it'll be a 5-4. Unless, and here's the case that I think we should take some hope in. Everybody remember the big push for assisted suicide as a right? You know, constitutional right to assisted suicide. Steve Reinhardt wrote that opinion. He thought it was going to be his Roe versus Wade, and the Second Circuit, New York, basically rendered the theory of double effect unconstitutional. Of course, they didn't understand that thereby rendering civilized life impossible, but that would be a different argument. I went up to the United States Supreme Court, and the United States Supreme Court basically said, we're not going to put our finger in that hole. You're asking us to make a huge change in American law, and this is maybe a straw in the wind. No, we won't do it. We have to remember that although we live in California, most of the country is sane. And there are, as I think last told, 5 states that recognize same-sex marriage, which means that there are 45 that don't. And I don't think that the court has an appetite to jam this down the throat of 45 states. I think that they learned their certain lesson in Roe versus Wade, that maybe that wasn't a great idea to jam that down the throats of the states. So I don't see this. And I take solace in this in the following. I read to you the definition of a fundamental right and how it's determined if it's not mentioned in the Constitution. And they look to the history and tradition of us as a people, as a society, and ask, is this implicit in the notion of ordered liberty? So it's a conservative act by the court. The court will be acting to confirm what the people have already confirmed. That should be what they do. That this is the way we live our life here, and we have an aberration. And we're now going to solve that aberration, but we're not creating a right as much as we are recognizing the existence of what the people have already determined to be a fundamental interest. So I think that given those concepts, that unless Anthony Kennedy has some view that this has to happen, I think it'll be a 5-4. You might pick up an extra vote, but I think it'd be a 5-4 in favor. And I think that, and more importantly, the people who oppose Proposition 8 really think that. That's why they didn't make it a challenge under the federal Constitution, and why, although they've gotten on the bandwagon because they had no choice, that's why they were not happy with Mr. Boies and Mr. Olson.